of a overview of where we're going. We're going to do a little bit about the history of work arrangements, some of the terminology, which can be very confusing, because a lot of it's legal, the size of these workforces, and some economic models, some actual case studies, and the health and safety implications, somewhat about the future. So we all know that we're experiencing a new industrial revolution. We survived the steam power one, the electric power one, creating mass production, Henry Ford, all that. The third industrial revolution we're still in, where electronics are automating all sorts of productive processes. And this fourth revolution, where we're tying physical entities basically to virtual or digital entities controlled by an algorithm. So if you look back in history, it's actually a very short period of time, probably from the 20s, 30s to the 50s, that you saw the first, second industrial revolution developing these vertical organizational structures. One job was differentiated from the other, and the corporation kind of arose after World War II. And what we consider to be a good job was being an employee, and when we use the word employee, we use it in the legal sense, which we'll explain, of a particular company, usually a manufacturing company in the United States, for your entire working life, or at least until age 65. And that was called the standard employment relationship, and it became the dominant model after World War II. And then the government built a whole bunch of social welfare laws, which we'll go over, using the same kind of model. So employees got job security and benefits and legal protections, and employees basically got a stable workforce, and they wanted a stable workforce because there was a lot of training associated with that, and we didn't want them running out the door after they had hired them. So starting after World War II, especially with Russell Kelly, Elmer Winter, and Aaron Scheinfeld, at the end of the war, you know, all these women were being dumped out of these war production plants, and they said, and they wanted to work, wanted to continue working. They said, we're going to find you a job for you. And it sort of was the beginning of this co-employment arrangement, which we call now temporary work. And the independent contractors were a small portion of that workforce, and they were very capable of taking care of themselves, okay, in terms of having enough resources to cover injuries that they may receive in the workplace, etc. Clearly, labor union representation started to fall after the war, certainly in the recent thing. There were threats to social benefit program solvencies. We've heard all of that. And the rise of the virtual workplace. So the drivers of change as you move closer to 2019 are the increase in digital communication technologies. Without that, you wouldn't see some of the new digital intermediated work going on, a huge growth in services from manufacturing, and the rise of smaller scale customized manufacturing processes, and work monitoring by technology as opposed to human supervisory. And the capital markets saying, you know, that really isn't your core activity. So if you have Marriott Hotel down the street, and the Marriott name's on the top, because of the brand, you go and start asking employees who you work for. Nobody ends up working for Marriott because they end up working for a subcontractor who hired them to do the restaurant or the cleaning or whatever. So this Industry 4.0, which is a German term that came from a white paper that they wrote in 2014, basically takes this new idea of monetizing unused time and access. So Roberto has a 9-bedroom house somewhere, right? And they're only using 1 bedroom, right? So he says, I'm going to put the other 8 bedrooms on Airbnb because it's an unused asset. It's a capital asset. But then he says, you know, I've got this nice Toyota Camry in the garage, and, you know, I hardly ever use it. I live in New York. So I think I'm going to sign up for one of these platforms and drive my Camry around picking people up. So that's a labor platform, okay? So 2 different kinds of economic platforms there. And then how does a platform figure out, you know, how to match people with paying customers? How do we match Roberto with a paying customer? And they're essentially crowdsourcing a workforce, okay? And it eliminates all the frictions that's associated with having an internal workforce. It provides more opportunities for work, you know, in that sense. And it certainly operates across a broad geography. Well, I'm not going to talk about international stuff. Other people are going to talk about that. I'm talking about the U.S. So when you look at the history of work arrangements, a lot of time we think, well, gee, this so-called standard arrangement, you know, it's really been around here a long time, and we're having this sort of disruption now. Well, actually, it hasn't been around here a long time. Non-standard work arrangements have a much longer history in capitalism than the standard arrangement. The standard arrangement may actually be looked at as an historical exception rather than the universal model. And in fact, the origins, we can trace it back to this mass production need that the Fordist assembly line required to have people who knew how to rivet whatever was going on as the car came by them. So this history of work arrangements, we can't forget it. That basically it is a short period of time, and it very quickly became the normative benchmark in terms of social protections, okay? Now, the terminology is very confusing because it's highly legalistic. And so if you go to a school of management, you get a chart like this, which has economic work arrangements at the top, and then it has employment and contract, and there's all sorts of variations. I simplified this at least to two major categories, employment and contract work. Now, there's actually two kinds of employment. One is the kind of employment I have, where I have one employer, full directive control and direction tests, so to speak. And then there's the co-employment relationship. We have two employers. You have an agency that dispatches you to a workplace, and then the client. So there's two employers there, co-employment, and that's the model of temporary work. And then there's contract work, which is direct or through a subcontractor, et cetera, and we'll explain a little bit more about that. Okay, so let's take the employment relationship, the standard employment relationship. You have an employee. That word is very important, okay? And I described the standard employment relationship, largely found in federal government, state government, although I must point out, Tesla has employees. Elon Musk doesn't believe in hiring contractors. One employer, one employee, and then co-employment, which is an employment relationship, two employers, the agency and the client, one employee. Then we get into this other world where we're out of an employment relationship per se, and we're into a business relationship, sort of an entrepreneurial relationship, where the organization that hires the contractor does not have directive control. They can tell you what they want done. They can hire an IT firm and say, come in to Sinai and redo our IT stuff, but they can't tell the individual contractor how to do it. So that is a major separation between employment relationship and a business relationship. Now, whether or not this third category is in that second category is one that we're struggling with throughout the United States. That is the issue where the customer and the platform and the provider of the service are all connected. But the platform will say, we're not an employer of that individual. It's a contract relationship. So the question that we have in all of these legal cases is, does the platform exert directive control? Because if the answer is yes, then it becomes an employment relationship and that person becomes an employee. If the answer is no, then that individual is a contractor, not an employee. So that is the essence. Now, whether that third category belongs in that second category, we have not settled as a matter of law or social policy in the United States. So this is, the standard employment relationship. You look in the American Legal Institute Restatement of Employment Law. I just wanted to go over with you the conditions for the existence of an employee relationship. And that third item there, the employer controls the manner and means by which the individual renders services. That is critical, and that determines the difference between the two. Otherwise, you're exercising entrepreneurial control over the business decision, okay? So that I want to emphasize, that is the essence of the difference. Now, for us, we think of a standard relationship not so much in these legal terms, but rather, it's a full-time job, 8 hours a day, 40 hours a week. It comes with an expectation the job is going to continue, and the work generally occurs at an employer's premises or in the employer's protected hold. Now that's eroding a little. And most importantly, if you're an employee, it comes with a bunch of social protections that are mandated either by the employer or the government, okay? Now what's important to remember here, and the only international point I'll make, is that in the U.S., social protections are attached to employment, not citizenship. Now in some countries, healthcare, for instance, is different in that case. So in the U.S., being an employee means a whole lot more than just getting money. And it means all of these things. So when we think about the safety net of federal and state laws, these laws apply to an employee only. And that word then is defined in each of those statutes. And they're usually very circular definitions that are unhelpful totally. So in the Occupational Safety and Health Act, I dare you to understand what the act means as an employee. Now, you could say, oh, the Congress is out of their mind because they don't know how to define things. Well, not really. What they really wanted to do when they leave this definition of employee in all these statutes kind of fuzzy is they expect a court to conduct tests based on factors that are indicia of employment. So they want the courts to settle all this in all of these, except the National Labor Relations Act actually has a real definition of employees. So this is an important point to remember here in non-standard work arrangements, that if you're not an employee, you don't get any of these goodies, okay? Very important. So the non-standard relationship, there's really no standard definition of a non-standard relationship. And it's largely defined by what is not a standard relationship. So there's no expectation of ongoing work. The work is not necessarily performed at an employer's workplace, can be very spatially distributed. And the arrangements are really market mediated as opposed to firm mediated. So that means that you're getting out of the four corners of the firm, the walls of the firm, in terms of wages and promotions and all that we go through in my employment setting, and you're outside of that and you're in a market kind of thing. The market determines what's going on. And as we just saw, there are few, if any. Now, if you're trying to figure out, what's going on here, it can be very confusing. So if you go to the U.S. Bureau of Labor Statistics, you'll find that they have a little bucket for contingent workers, where they say, well, these are people that have no implicit or explicit contract for ongoing employment. Okay, all right, fine. I mean, I don't really have an explicit contract for employment. I can be gotten rid of at any time. So am I a contingent worker? Probably not. Then they have these alternative employment arrangements, which are more acceptable to understand. So we have an independent contractor, an on-call worker, a temporary help worker. But I understand what that is. A temporary help agency worker is someone who is dispatched by an agency to a client. Understand that. And workers provided by a contract firm, which are large firms that take over the personnel functions of all of Mount Sinai, for instance. The gig, which is a term we use a lot, has nobody's definition, even in the BLS, and amongst researchers, which is a big problem. And we have electronically mediated work where BLS is trying to get a handle on this, as we'll see, and they're sort of defining this as the way we understand it, where a company's mobile app connects the individual, and I don't want to use the word employee or worker because that suggests that the legal issue's been settled with customers, okay? Paid for by the platform, they choose when and how to work, etc., and we'll see BLS's effort in this thing. So the size issue of this workforce is anything but settled. In 2005, BLS did a survey basically saying 10.1%, okay? Katz and Kruger, these are economists, did a thing. They said, we think it's up to 15.8. GAO did something, a wild sort of thing, up to 33%. It's all over the map, obviously. So BLS did a best effort. They released a survey June 7th last year on contingent and alternative employment arrangements. And they separated these out, contingent and employment relationship, and I summarized it here. So basically what they did in 2005 for a total, put all these categories together, they said, well, 10.7% of the workforce falls into those categories. And then, as a result of the 2017 thing, they said 10.1%. Everybody went, what the hell? We thought this particular type of employment was increasing, or entrepreneurial, or contractor, whatever you want to call it. And you guys are saying it went from 10.7 to 10.1. So they got a lot of blowback. Katz and Kruger said, well, you're failing to capture a lot of this secondary work because there are people who have an anchor job, like Roberto, but he's out there on the weekend with the car, driving it around for Uber, okay? So it's not a major part of his employment. So they said, you're missing those people. Freelancing in America, which is actually located here, I think, in New York, said, well, you know, if you ask about just a 1 week period of time, you may get zero because not everybody in that type of work does it every week, okay? And then Katz and Kruger came back and said, you know, asking Uncle Jim, who happened to answer your phone when you called, about the person's work, having this proxy responder, and all you epidemiologists know, all the pitfalls, that's wrong. And then finally Gallup, which never criticizes anybody, said, look, your questions are just poorly worded and a mess. And I just wanted to point out there's another literature besides what BLS uses, which is the current population survey, okay? There's another thing. Well, you can count up the number of 1099s that are being filed with IRS. A whole nother literature. If you look at that literature, we don't have time to go into it today, they'll say their percentage is about 11.8, and a paper published from the IRS in March actually is a good paper if you want to find it out. So then BLS said, well, let's count these people that are actually in this category of electronically mediated work. So they came up with this term, electronically mediated work. This was a mess. The questions didn't work out as they thought. They had to go back and manually look at every answer. And at the end of that, in May, they said 1%. Okay, so who knows? The problem is that the BLS sort of gave up and said, you know, we need to go to the National Academy. We need to figure this out. This is not working for us. And much to their credit, they have done several meetings. The third meeting was just recently of the National Academy, trying to figure out how do you measure this workforce. So right now, it's hard to know the size of this workforce. So I want to talk to you just briefly about some gig economics, so to speak, from the upside. As we said, you know, a few minutes ago, it creates surplus value in the economy because some labor and some capital are not being used, but in this type of work, it can re-enter the economy. So the economists say, you know, you're taking surplus value and you're putting it back into the economy. And then, you know, on the upside, it certainly matches customers' demand and work supply a lot faster because I use the app and you go to it and the car can come out here, it's ride sharing and all that. And it intermediates that. And as we'll see in the theory of the firm, which was established in the late 30s, a lot of issues or frictional costs associated with getting a workforce into your workplace, getting them trained and all that, those are all frictional costs of operating a business. Well, this intermediated work eliminates a lot of that. It essentially reduces those costly search frictions down to zero because it crowdsources that service, okay? So the economists will say, you know, this may not be that bad of a deal. The upside for employers that engage in this is a whole lot of flexibility, achieving greater efficiency. So there's functional flexibility where you can certainly assign workers a lot faster by virtue of your digital app. It gives you numerical flexibility, just like seasonal work, you know, Christmas, you know, Macy's staffs up and all that. So if there's a downturn, a recession, whatever, you know, goodbye, I'm sorry, you're gone. Getting rid of an employee, terminating an employee is a very complicated situation. And, clearly it provides you a lot of financial flexibility in terms of labor costs. As we know, an employee costs 30 to 40, depending on where you are, 30 to 40% greater than the salary that you're giving them in benefits, okay? Now, the issue, though, for a lot of employers, which is, if your person that you're hiring is at the core of what you do, that employer may want some competencies in that individual that they want to train for. And an employee may be better off for them than a contractor who may be at the periphery. So if the peripheral functions of your business can be done by contractors, that is a more equitable arrangement for a lot of employers. Now, the downside for employers, and there's not a lot, but the downside for employers is sort of deciding, which arrangement to use and which task. And then the management aspects, if you're down at frontline management, is you've got this blended workforce problem. So you could have some traditional employees, you could have some temporary employees, you could have some digital employees, and you have to do a safety culture for that particular unit. Well, if you've got to constantly go back to the agency where the temp employees are and all this and that, and how do you include them in there, it does create a lot of issues. For the standard employees, there's a lot of data that shows that they don't really like this that much because they're a little worried about whether their job can go that way, and issues related to that. Co-managing issues with the temp agency can be a real challenge. And then for the employer, in terms of the downside, if you guess wrong, and the IRS says, that's not really a contract. You really have an employee on your hands there, and you haven't paid any of the employment taxes, then you've got a big problem. So that's a whole misclassification issue, which is a very big one that we see throughout. Now, the downside for gig economics is that, these companies that are doing a lot of intermediated work, they're essentially maximizing profit, but it's not through any productive enterprise that we usually associate with goods production, okay? So that's one problem. The second is that they're taking some advantages, perhaps arbitraging some tax and regulatory issues in order to have a profitable business. And many of these companies have been accused of that. They may be, frankly, evading employment law by deliberately classifying employees in this category. And lastly, it leads to a lot of externalities in terms of devolving all of that safety net stuff, okay, onto this micro-entrepreneur, which a lot of companies prefer to call these people. So it's now becomes their responsibility to have a lot of those things, as we'll see. The downside for workers is exactly that, is that, it transfers a lot of those business responsibilities to them, but not everybody's really interested in operating a small business. And the small business micro-entrepreneur, if you will, lacks negotiation power with the platform. The platform can delete you like that, and you can't set your own prices, so you can't grow your business in the traditional sense. It's really hard to engage in collective action because you don't know the rest of your drivers or others that may be separated spatially. And it certainly dilutes any motivation in that regard. And clearly, as we'll see, there are risks to health, safety, and worker well-being. The upside, though, is there's a lot more autonomy with this kind of work. You can decide when to work and not to work. It enhances work environment variety. Perhaps it enables career exploitation, not perhaps in the electronic mediated work, but in your other anchor job or career, if you're a student or something like that. And it can enhance income beyond your anchor job. And lastly, you could get more control over work-life balance than oftentimes in a traditional job. Now, we could spend all day talking about the legal cases, and they basically boil down to no matter what statutes you're looking at or what court you're going to go to, they're going to try to figure out what's the test to determine whether this individual is an employee or are they a contractor. In OSHA law, it's a common agency test, which is control and direction. It's a 10-factor test. For wage and hour, they use the, for minimum wage and all that, they use the economic realities test, a little broader. Now, nothing can be outdone in terms of the IRS. They have a 20-factor test, which has behavioral control, financial control, and relationship with the parties. And courts go through all of these factors, and these are very circumstance intensive. And no one test, you think this is, how crazy can this get? But no one test or grouping of factors has achieved any kind of national consensus in federal court or state court. So each of these courts, depending on the statute, they apply. Sometimes they mix these things together and come up with a hybrid kind of thing where they take 5 from here and 2 from there or whatever. It's really quite nutty. I really can't emphasize more than the law of employment classification is very, very, very confusing, and it has created lots of issues. So there's a lot of platform litigation out there. I mean, every platform company is involved in some litigation, at least from a city or a state saying you're treating these people wrong, or from the individuals themselves who are saying, you know, I'm an employee and you're not giving me those kind of benefits. I wanted to point out this one case. This is from the California Supreme Court, Dynamex Operations West versus Lee. California Supreme Court adopted what's called the ABC test. And they basically stated in order to classify someone as an independent contractor, the business must show that the worker is free from control and direction. Okay, we knew that already. Worker perform work that is outside the usual course of the hiring entity's business. The worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed on that. So you can't do that. So what this case was a delivery company. And these were drivers for a delivery company. And they tried to argue, well, we don't actually do delivery, even though we're a delivery company. So that didn't work. But keep that in mind because we may see it again. And what the California legislature did recently, and the governor signed on Wednesday, 2 days ago, Assembly Bill 5, which basically takes those Dynamex criteria and puts them in a statute. Now, Uber and Lyft and others, and Uber's located in San Francisco, is claiming that, well, we don't really fall under the Dynamex case that's in Assembly Bill 5 because we're a technology company. We don't drive people around. Okay. So I would predict that, one, that we'll see this in court because it's America. We see everything in court. And two, we may see, because some of you may know California is like Athenian democracy, we have initiatives that go on the ballot, and I'm sure Uber will put an initiative on the ballot trying to overturn the legislation. But this is the most populous state in the union that probably has about 1 million of these type of workers. And it's not just ride sharing. You know, during the process of Assembly Bill 5 being considered, there were synagogues that said, well, our rabbi's on contract, we won't be able to afford them, we have to pay all these, you know, benefits and all that. Barbershops, I mean, it went on and on. Everybody wanted an exemption. So this is going to be interesting to see whether, how it turns out. This is probably, to me, the most fun. You can have fun with law. So this is the U.S. Court of Appeals for the 7th Circuit. And what happened is the taxi drivers in Chicago sued. And they argued that the city of Chicago was depriving them of a property right because it discriminates against taxis by failing to subject Uber to the same rules about licensing taxis, okay? So Judge Posner had a really great argument. So he said, well, most cities and towns require dogs but not cats to be licensed, okay? And there are differences between the two animals. You know, dogs are bigger, stronger, they have, you know, bite more than cats. Dogs are feared by people, cats run away, and they bark and howl and carry on. And feral cats are innocuous, you know, they run away. And dog owners may like cats to be licensed, but they don't argue that the failure of government to require that a competing animal, a cat, be licensed deprives the dog owners of a constitutionally protected right. This is an hysterical opinion that you really should read. So the plaintiffs basically, Judge Posner said, have no stronger argument for requiring that Uber be subjected to the same licensure as taxi owners do. than dogs have about cat owners. So it's really a fun case and probably the most fun you'll ever see. So we'll get to the health and safety issues, and the major point that I wanted to mention here, because this is a rich area for research, is most of our research findings can be found in the temporary agency arrangement. We have very few studies, and most of them are from Europe, from Spain or Finland, on platform work per se. And we'll see why, because we're trying to figure out what's the exposure here, okay? And we'll see that at the end. So I just wanted to point out that there are way more staffing agency offices in the United States than there are McDonald's, okay? They're probably within a rock throwing here of Mount Sinai. There's probably a staffing agency somewhere, especially for a big hospital like this. And we can see that, it's grown from, Russell Kelly and Kelly Services, now Kelly Girls, and then Kelly Services, which was primarily sort of desk automation kind of stuff, clerical. We see it now throughout all industries, and certainly it's quite significant. So we look at mental health issues. A lot of studies have shown that issues related to employment, unemployment, organizational restructuring, forced downsizing, that results in psychological health. And Marie Vertinen, who's did a great study, meta-analysis of 27 studies, suggesting higher psychological morbidity among temporary workers compared with permanent employees. She did that in 2005. And it could reflect, the job insecurity issues. Again, we're talking about what's the exposure here, financial instability, or other social determinants. And I encourage you to look at these papers. Now, the risk of injury in temporary workers, there are quite a few European studies, but there are also U.S. studies. In petrochemical facilities in the mid-90s, temps had twice injury rate in a plastics manufacturing study in late 99. Workers' comp injury claims for temps double those of permanent workers. Some of you may have read the ProPublica article where they looked at Florida's worker compensation data in 2013. And clearly, these are important studies, but they are in temporary co-employment work arrangements. The Washington State Department of Labor and Industries, in their OSHA program, WSHA, has looked at this issue, temporary versus permanent compensable claims. And you can see that the ratio is much higher for temporary workers, especially in machine operations and vehicle operation, construction, and ag services. So, if you look at all these studies, naturally you could say, well, why? Why is this happening? A lot of studies have shown that the job assignment that temporary workers have usually are the most risky, and certainly we've seen that in turnaround situations in petroleum manufacturing. It's the contractor employees get the real hazardous job. And some of them, studies have shown, well, those folks have less experience and familiarity with the operations, they have fewer hours of safety training, and they have more distant relationships with the longer-term workers because you don't necessarily know who they are, and a lot of times you depend on workers who are there, who have long histories there to tell you about certain issues. Some studies have said there's limited availability and use of personal protective equipment. And this one, the third bullet to me is the most important. If you're there, you're the first day as a temporary worker, second day, whatever, you're certainly less likely, you're certainly incentivized, unless you're a very different kind of person, to report an unsafe condition that you may see or have been exposed to because you're a temporary employee. And, you may say that, you may bring it to somebody's attention, the client calls the agency, and you're gone the next day. And then the last is, according to the American Staffing Association, there may be some real, or certainly perceived, lack of understanding about the responsibilities of the agent and the client. And certainly that's true given some of these issues about who's an employee and who's a contractor. Mortality risks, lots of studies. The Finnish study was a huge study. Mortality 1.2, 1.6 times higher among temporary employees. What's interesting, when they moved from temporary to permanent work, the mortality risk went down. So that, I think, is an interesting finding. But you can even look in the U.S., and if you look at self-employed, all the self-employed people versus all workers, you can see a mortality difference in BLS data. What we did with OSHA in the last administration, we worked with the American Staffing Association to come up with some recommended practices for protecting temporary employees, and that's on both of our websites. But this is the point where I wanted to say, okay, so if you wanted to research this issue about the digital workforce, what is the exposure of the arrangement per se between an employer-employment relationship and this, whatever this thing is going to be called, this digital intermediated arrangement? Can we measure temporariness somehow? The duration of the contract, the empowerment issues, can you schedule? Can you determine your work hours? Can you determine your wage? How vulnerable are you? What is the relationship? Can you demand better work? Are you defenseless towards mistreatment, etc.? And then in terms of the wages, what are the wages like? Do they meet basic needs? Unexpected thing? Are there fringe benefits, etc.? And then what rights do you have? In the U.S., there are none if you happen to be a contractor. And then you have access to those rights. No, you don't, because you're a contractor, not an employee. So the EPRA scale is a Spanish scale done in Catalonia by John Banach, who is a fabulous researcher in this area, and his whole group has produced most of the papers. And the EPRA scale is now used, and on the other side is the scale that we're trying to develop to study this issue. Again, what is intrinsically the exposure of the arrangement, not what you're exposed to in the traditional occupational safety and health sense. So the research challenges in this area are significant. One, there's no agreed on definition of non-standard work arrangements. So researchers need to know what they're trying to identify, and that is going to be a big problem. The surveillance methods about the extent of non-standard arrangements and the number of workers involved, you see that in this sort of mess I presented, we're a little unsure as to the extent of that. And then the models for employment quality. Some of those issues, we're going to use the basic psychological models, we're going to use something else, may or may not be useful for non-standard work. And clearly, a lot of studies are needed, and I think it's a great area of research. But we certainly know that employers using non-standard work arrangements are shifting the burden of protections and all of those types of safety net from them to this individual, this worker, this contractor, this whatever. And the evidence is pretty substantial that temporary agency workers are at higher risk. The risk profile for platform workers is really unknown, but certainly of concern. So we do need better taxonomy, better surveillance, and new research methods. I wanted to just briefly end with some issues related to the future. These are all very futuristic. Orly Lobel, who's a law professor, has written a number of articles here saying that worker classification is not just unique issue to the platform. The Fair Labor Standards Act, which determines wage and all that, 100 years it was passed ago. And its classification test is still a mess in the courts. And so the problem at the heart of classification is not the newness of the platform, but the existing classification test and DOL's various guidances, which come out 180 degrees different depending on the administration. So what she says is, look, maybe we can just get rid of classification and make some issues classification neutral. And in fact, in Washington State, they have a very expansive definition of employee under its state anti-discrimination protection code. The question is, can we do that in safety and health? The issue about who pays for injuries is a significant one and may motivate action in in this area, because injuries happen whatever the label is of the worker, clearly. And who pays for that medical care? A worker, intermediated platform worker, an employee through the workers' comp and the health care benefits and all that. So the individual, you can pay for it on your own. You can use your health insurance from an anchor employer, but that's a little sketchy, because you could be, they could find out you're claiming an injury that did not occur on their workplace. You could sue the platform. I wouldn't think that would get you anywhere. Or you use your own accident insurance. You buy your own. Or the platform could contribute a share to a portable benefit system. What happens, though, is that we all pay for it, because it ends up going into Social Security disability insurance, which has ballooned of late. Uber is now thinking about offering sort of this, I put this in quotations, worker comp insurance in some states. This Uber insurance is a little limited, and it's probably not a workers' comp policy as we understand it. But the question is whether it's the beginning of developing a safety net for these. Now, obviously, the California legislation is going the other direction, but this may work in some other states. One interesting idea is, well, you know, there's this employee and this contractor, and we've spent the last half an hour talking about the mess between the two, but maybe we need to come up with something new, a new classification. So in Canada and Germany, when an independent contractor has worked exclusively for one client for a long time, the courts there consider them a dependent contractor, and you'll see that term in the literature. Well, the Ninth Circuit, in a case with Microsoft, declared long-term contractors permatemps, so like permafrost, but permatemps, and actual employees with full benefits, okay? Well, you know, Microsoft lost the case, fine, and what they did was, the court said, well, when they have to decide a time limit for this permatemp thing, the 270 days, so Microsoft just let everybody go at 269 days and then rehired them. So you can arbitrage, you know, this stuff no matter what. So I don't think that worked too well. Harris and Kruger, Seth Harris was a former DOL official, and they came up with this independent worker. Now, this hasn't really, you know, flown very well, but it would require substantial revisions to all those statutes, which I think is unlikely. Eli Lehrer in 2016 thought of this classification of flexible worker, and it would be based on a worker who is involved with this job platform work, and it would essentially take all of that safety net that the government provides, and it would privatize it. Now, Eli is from the R Street Institute, which is a very conservative think tank in Washington, so clearly it's a private market approach. And then there's been some new social benefit ideas where you could construct a market for portable benefits and get the insurance companies involved in that. That's one of Eli's ideas. And of course, the other, which is more of a European model, is attaching social protections to citizenship and not to the employer relationship, so you don't have this constant mess dealing with employment law. And then, you know, on the campaign trail, we hear about, you know, the universal basic income issues where we're, you know, all going to be automated and all that. Andrew Yang talks about that, but it actually started with Charles Murphy in that area. The portable benefits model is being worked, and here in New York it's also happening, and in California. So I think that, you know, the bottom line is that workers in the standard arrangement still vastly outnumber non-standard workers. And non-standard worker arrangements are not new in capitalism. They've been around a long time, and they haven't gone anywhere, and now they're back. We do not know with certainty the size of the workforce engaged in non-standard work arrangements, except probably if you call the American Staffing Association, they'll tell you about co-employment arrangements, but certainly not for platform work. We're still trying to work that out. And the determination of who is an employee differs, as we've seen, statute to statute, making for years and years of legal controversy in the United States. Clearly, all work arrangements pose safety and health risks, whether they're standard, non-standard, alternative, worker. Some pose greater risks and some pose less, and others, like platform work, are really unstudied. And I suggest that anybody who's looking for projects, start thinking about that issue. So thank you very much. Happy to answer any questions if you all have any.